Morning everyone and welcome to The Box, and this is the third session in our series of bite-sized webinars for insurance brokers, intermediaries and their insurers. My name is Ben Hardiman. I'm a partner in our insurance disputes team here at Mills and Reeve, and today I'm joined by my colleague Ian Tattersall, who is an associate. Today we're going to spend about 15 to 20 minutes talking about the apportionment of liability between retail and wholesale brokers. If you have any questions during the course of the webinar, please post them in the chat, and James Thompson is on hand to act as quizmaster to pick our brains, and we'll try and pick them up at the end. And finally, the session is being recorded, and so it will in due course appear on our website and our YouTube channel in due course. So just to start with an overview of what we're going to talk about today, firstly, I'm going to be discussing who owes a duty of care to the policyholder. Ian will then look at some of the main cases dealing with apportionment between brokers, and then I'll finish off with some key practical takeaways, whether you generally find yourself on the retail or the wholesale end of things. So when we think about apportionment, I think the best place to start is the relationship between the parties, and the structure we're going to focus on today is to take us from the client, the policyholder, to the retail broker, often also known as the producing broker, and from then to the wholesale broker, otherwise known as placing or sub-broker, and it is then the retail broker who communicates with underwriters. And why does this happen? Well, historically, a non-Lloyd's broker needed to use a Lloyd's broker if a risk was to be broked into Lloyd's. And more generally, brokers, often regional and smaller brokers, may need the skills, expertise and access to market that a specialist wholesale broker can offer. So I'm just looking at the duty to the policyholder from the retail broker's perspective, and this is fairly quick. This is a standard situation. When you think back to the relationship diagram, which I've replicated at the bottom of the screen, the retail broker has a direct relationship with the policyholder. They will owe a duty of care in contract and in tort. It doesn't matter whether that relationship is recorded in writing or not, the existence of the duty to act with reasonable skill and care will be implied. The position is a bit more complicated when you come to the wholesale broker. Again, if you look at the relationship diagram, the wholesaler's relationship is with the retail broker and not the policyholder. So in terms of the contractual matrix, it will only be in exceptional circumstances where the wholesale broker will be found to owe a duty of care in contract to the policyholder. Now, I've mentioned the Prentice, Donegan and Partners case on the screen. That involved a US retail broker placing a policy into the Lloyd's market using a Lloyd's broker. Now, it was actually a dispute about responsibility for payment of premiums and the division of brokerage. So the facts of the case aren't relevant to a talk on apportionment. But what is important is the general principle it laid down. And importantly, the privity of contract between two parties, in this instance, the retail and the wholesale broker, and not the third party, i.e. the policyholder. So as a consequence, there will generally be no direct contractual relationship between the wholesale broker and the client. It would require a clear intention from each party in the chain, and that almost certainly means it's going to have to be written down for a contractual relationship to be created. So is that the end of it for the policyholder? Well, let's look at the position in tort. And there is perhaps a bit more scope for the policyholder if you go back to basics on how duties in tort are established. The policyholder will need to show that the wholesale broker assumed a responsibility to them and that they place reliance on the actions of the wholesaler. Now, generally speaking, that is actually quite difficult, and these cases are very fact specific, but there may be certain aspects of the instruction to the wholesale broker that help to establish that relationship in tort. And so we've got two cases on the screen which just give a bit of skin on the bones of this issue. So in the BP and Aon case, the wholesale broker had taken on responsibility of making declarations to insurers. In order to do so, and this is perhaps the unusual situation compared to a standard retail and wholesale relationship, Aon were in direct contact with the policyholder. And it was that direct conduct by Aon, the level of communication between the two, which led to the court deciding there was an assumption of responsibility and that there was a reliance by the clients. So that amounted to the necessary ingredients to establish that duty for the wholesale broker to the policyholder in tort. Now, contrast that with the second case on the screen, the Ilvanert management. Here we had a Greek retail broker acting on behalf of a Greek ship owner who used a Lloyd's broker to place cover for a yacht. The insurer was able to avoid cover due to non-disclosure of material facts on what was ultimately a total loss amounting to around £13 million. Now, while the Greek retail broker was found to be liable to the ship owner, the Lloyd's broker, and this is in sharp contrast to the Aon case, had no direct communication with the policyholder, nor did the ship owner adduce any evidence to show that it relied on the Lloyd's broker. So consequently, the Lloyd's broker was found to owe no duty in tort and obviously no duty in contract. And in fact, the Lloyd's broker was found not to have acted negligently in any event. So the Greek retail broker, who was liable to the ship owner, was unable to pass any of that liability on. So if a policyholder will find it very difficult to establish a liability against the wholesaler, does that mean the wholesaler is safe from claims? And I think the simple answer to that is no. Whilst the wholesale broker may not owe a duty to the policyholder directly, generally speaking, it will owe duties in contract and tort to its retail broker. And if you think back to that relationship structure diagram, what you have is a chain where the policyholder instructs the retail broker then subcontracts at least some of those responsibilities that it assumes to the wholesale broker. And it's that relationship which gives the retail broker the potential basis to argue that it should be entitled to recover damages, which would then be quantified by reference to its own liability to pay damages to the policyholder. And I'll just consider that aspect of things in the takeaways section at the end. But before we get to that, I'm going to hand over to my colleague Ian, who's going to consider 3 particular cases in which this tripartite relationship was considered. And do make sure you listen, because Ian has a little test midway through this, so you need to be on the ball for that. Ian.
Thanks, Ben. Good morning, everyone. So the first of the cases on apportionment we'll be covering today is the 2009 Dunlop decision. So this contained professional indemnity insurance for a group of companies that operated in the property sector. And part of that group was a commercial valuation company. Because of a concern that the valuation work it undertook could expose it to significant liabilities, a £10 million excess layer cover policy was obtained. The excess layer policy came up for renewal, and the retail broker asked the wholesale broker to obtain quotations for the commercial property management activities of the group. The wholesale broker carried out that instruction and sent a report which mentioned cover had been obtained on this basis to the retail broker. The retail broker then simply forwarded that report to the policyholder. So following inception of the excess layer policy, a number of valuation claims were made, which you'll recall was exactly the situation the policyholder wanted to protect against. However, the excess layer insurer was able to successfully decline indemnity on the basis these claims did not fall within the scope of cover. In view of this, the policyholder sued the retail broker, who in turn sued the wholesale broker. So who do we think the court felt was at fault for the inadequate cover? Well, as you can see from our pie chart, the court felt the retail broker was predominantly to blame. The wholesale broker was criticised for failing to follow instructions to obtain cover on no worse terms than expiring cover. It was also criticised for failing to spot the renewal policy represented a significant change in cover. However, the retail broker came in for the majority of criticism for firstly instructing the wholesale broker to obtain excess layer cover for commercial property management activities, which was not what was required, and secondly, for failing to highlight to the policyholder the restriction in cover once it received the wholesale broker's report, which identified the limited scope of cover. Have the next slide, please. So the second case we'll be looking at today is the 2016 Ocean Finance decision. Again, this concerned a professional indemnity insurance policy, but this time for a finance broker who had missold PPI on a systemic scale. The PPI problem came to light during 2009, and the wholesale and retail broker had discussions as matters developed. Without instructions, the wholesale broker made limited notifications to the 2009 policy, some 500 PPI matters where claims had been made. After taking legal advice, the policyholder made a block notification to the 2010 policy around 10,000 matters where no claims had yet been made. However, whilst the primary layer insurer took no issue, the excess layer insurer successfully declined cover on the basis notification should have been made to the previous year, which is the 2009 year. So who bore responsibility for not making the block notification? Next slide, please. Thank you. As you can see, it's the retail broker who's coming off worse again. And the reason for this centered around what the brokers knew. Whilst the court was of the view that both brokers had failed to grapple with the question of block notification in 2009, it felt the retail broker had much more knowledge of the widespread nature of the PPI problem, and the question of block notification should have been more apparent to it. Go to the next slide, please. So the final case we're looking at today on apportionment is the 2007 Fisk decision. And this is the one with the poll at the end. So we're going to ask you to predict the outcome. So do listen carefully to the details. It concerned a property insurance policy for a 16th century pub, and cover was taken out in 2000. In connection with this, the retail broker, who knew the property well, completed a proposal form which contained incorrect and incomplete information over its construction, including that the property was made of brick, stone, or concrete. On renewal the following year, the wholesale broker moved cover to a new insurer whose policy included a warranty over the construction. However, the wholesale broker didn't advise the retail broker of the change in insurer, didn't advise them of the presence of the warranty, and didn't seek authority to give the warranty. The wholesale broker also didn't seek to obtain a fresh proposal form prior to placing cover. Unfortunately, there was then a flood, and the insurer successfully declined cover for breach of the construction warranty and for failing to disclose the true nature of the property's construction. So who do you think bore responsibility? We're going to have a poll pop up shortly with some options, and I'll give you about 30 seconds so you can tell us what you think. Yes, that's the decision that I thought you might reach. So if we could have the next slide, please, and we'll see what the actual outcome was. You'll probably find it was a little surprising that how poorly the retail broker fared. So how did we get to this? Well, it's worth noting this was an appeal decision, and the outcome had been even worse for the retail broker at first instance. The judge had held the retail broker was solely liable, and that the loss was caused by its thoroughly misleading proposal form, rather than any of the actions of the wholesale broker. On appeal, the court felt the major share of the responsibility rested with the retail broker. However, it considered some culpability lay with the wholesale broker. Firstly, whilst the wholesale broker sought to argue it had relied on the retail broker's proposal form, the court considered the form was not sufficiently clear to give the warranties in question, and queries should have been raised by the wholesale broker. Secondly, the court saw it as significant that, whilst the policy allowed cover to be refused if there was a difference between the quotation and the proposal form, the wholesale broker did not, but should have, sought a fresh proposal form. I'm going to pass back to my colleague Ben now, so he can wrap up with some key takeaways.
Thanks, Ian, and on to the final slide, which is the takeaways and how to manage your risk. And I'm looking at this whether you're the retail broker looking to work with a wholesaler, or vice versa if you're a wholesaler taking instructions from a retail broker. And the first point, I think, is that the cases show that the relationship between the parties is critical. I think retail brokers might want to expressly point out to their clients when they're using a wholesaler and the reason why they're doing that. Now, that won't result in a contractual relationship between the policyholder and the wholesaler, but it might be enough to help put in place the building blocks for the creation of the duty and tort. Now, why is that important? Well, if the policyholder has no ability to claim from the wholesale broker because it's got no contractual or tortious relationship, the onus will then switch to the retail broker to pursue the wholesaler in the event it receives a claim from the policyholder. And that means it's the retail broker and not the policyholder who takes all of the risk of bringing that claim. And that includes the potential cost liability if that claim for contribution down the chain is unsuccessful. So it's arguably in the retail broker's interests to help the policyholder create that closer relationship with the wholesaler. I've mentioned contracts and terms of business on the slide, and here I'm talking about the contract or terms of business between retail and wholesaler. Having a formal written contract which is signed is obviously in both brokers' interests, but I think wholesale brokers may look at this as an opportunity to establish the terms on which they're prepared to trade. So, for example, providing clarity on which party is responsible to take which actions, or potentially importantly, creating a limitation of liability in the event a claim is passed down the chain. Now, finally, a talk about broker claims wouldn't be complete without some reference to evidence and communications. And problems that we see often arise because of a breakdown in communications. So, for example, does the wholesale broker have sufficient information to effectively understand the risk and place it and to communicate with the underwriters? Is there a lack of clarity about that information? If not, the wholesaler should be asking questions of the retail broker to enable the retailer to then elicit that information from the policyholder. In general terms, the courts have tended to impose the greater share of liability on the retail broker because they are the closest to the policyholder and they have the greater knowledge of the policyholder's business. So that's something I think wholesalers can leverage in terms of protecting their position. From the retail broker's perspective, do you have all of the necessary documentation and information from the wholesaler? Have you got a copy of the policy? This is often something we see in situations where there's a renewal and even where the policy has remained with the same insurer. Sometimes terms have changed. If you haven't got a copy of the policy, how will you fulfill your duty and your obligation to advise your policyholder? What about particularly complex terms? If you don't understand the terms, how are you going to advise your policyholder? One of the reasons why courts have imposed liability on wholesale brokers is because they are viewed as the specialist. So as a retailer, use that specialism. And finally, what about claims? Whose obligation is it to notify insurers? Often it'll be down to the wholesaler, but does the wholesaler have sufficient information to understand the claim and make an effective notification? If you're the retailer, make sure you've got confirmation that the wholesaler has notified and that the notification has been accepted. And just on top of all of this, ensure those communications are documented by way of an email or a file note. I do hope that's helpful. We've wrapped up just within our 20 minutes. I'm going to pass over to James now to pass on any questions which have come through on the chat. James?
Hopefully you can hear me again. I've got a couple of questions here. I think the first question probably is one for Ian. Ian, do you think the court's decisions on apportionment show a trend of holding the retail broker predominantly liable?
I'm not sure they necessarily show a trend, although I understand the point's been made. I think it's fair to say when the court is considering the majority of the duties that a broker should perform, the proximity that the retail broker has with the policyholder means that the retail broker is going to be more likely to be responsible for most issues. However, there could be cases where that proximity doesn't play as an important role. And in those cases, the wholesale broker could have an equal or higher degree of responsibility. It just wasn't the case on the three examples we've looked at today.
That's really helpful. And Ben, a question for you. Says, I'm a regional producing broker and I sometimes need a broker with a London market specialism, and we always use the same broker who we get on well with. We don't have a formal contract, but do you really think it's necessary?
Well, I suppose going back to what I would say, yes. I mean, it's not simply setting out responsibilities. It's important in terms of setting out issues such as payment, issues such as responsibility. As I mentioned earlier, it may be something to enable the parties to set out restrictions on the liability they may hold. A contract will exist. The terms will be implied, but I think it's always best practice to have those terms written down and signed so that each party knows where they stand.
Yeah, absolutely. And just finally, it's more a comment than a question. He says the retail broker often plays down the role of the wholesale broker, often describing the wholesale broker as the insurer or the London markets. Do you think that's is that something that you see in the claims that you deal with? And I mean, obviously that sort of confusion as to what the role of the wholesale broker is, I guess, is going to be key in understanding what the various parties' duties are.
Yeah, I think it is true, and I think the impact of this. I mean, I suggested that the retail broker may wish to almost highlight the involvement of the wholesaler. I can see why there'd be a reluctance to do that. In effect, you're passing on some of your responsibility as the party who is advising the ultimate client. But it goes back to protecting your own position and what will happen in the event of a claim. Touch wood, it won't, but as Ian's example showed, it can happen. And as I showed in the Ilvonert case, not getting this set up correctly does create problems. So I can see why there's a benefit to it. Equally, I can see why there may be some reticence. So
great. And that's all we've got in terms of questions.
Okay, well, thank you. That concludes our session for today. Thank you for joining us. Thank you for the questions. Please do join us for the next session of The Box, which is on the 8th of June, where James will be speaking with our colleague Shanice about the recent ABN AMRO case and around the issues of the insurance broker's duty to protect its client from the risk of litigation. So thank you for coming.